The Habeas Corpus Act 1679 is an act of the Parliament of England passed during the reign of King Charles II by what became known as the Habeas Corpus Parliament to define and strengthen the ancient prerogative writ of habeas corpus, a procedural device to force the courts to examine the lawfulness of a prisoner's detention in order to safeguard individual liberty and thus to prevent unlawful or arbitrary imprisonment. Earlier and subsequent history. The Act is often wrongly described as the origin of the writ of habeas corpus. But the writ of habeas corpus had existed in England for at least 3 centuries before and traces its origin back to the Magna Carta in 1215, whose Article 39 reads, "No freeman shall be taken or imprisoned or disseized or exiled or in any way destroyed, nor will we go upon him nor will we send upon him except upon the lawful judgment of his peers or the law of the land." The Act of 1679 followed an earlier Habeas Corpus Act of 1640, which established that the command of the King or the Privy Council was no answer to a petition of habeas corpus. Further Habeas Corpus Acts were passed by the British Parliament in 1803, 1804, 1816 and 1862, but it is the Act of 1679 which is remembered as one of the most important statutes in English constitutional history. Though amended, it remains on the statute book to this day. Content: in criminal matters other than treason and felonies, the Act gave prisoners or third parties acting on their behalf the right to challenge their detention by demanding from the Lord Chancellor, Justices of the King's Bench, and the Barons of the Exchequer of the jurisdiction a judicial review of their imprisonment. The Act laid out certain temporal and geographical conditions under which prisoners had to be brought before the courts. Jailers were forbidden to move prisoners from one prison to another or out of the country to evade the writ. In case of disobedience, jailers would be punished with severe fines which had to be paid to the prisoner. Parliamentary history: the Act came about because the Earl of Shaftesbury encouraged his friends in the Commons to introduce the bill where it passed and was then sent up to the House of Lords. Shaftesbury was the leading exclusionist, those who wanted to exclude Charles II's brother James, Duke of York, from the succession, and the bill was a part of that struggle as they believed James would rule arbitrarily.